Okay, we always like to start as close to on time as we can because we always have such great questions and conversation at the end. And I think we really want to leave time for that again. So I will start to welcome us all to today's September's webinar for Dementia Care Aware. Very excited about today's topic, which is primary care's role in assessing decision-making in patients with dementia, a medical legal perspective. And our distinguished guest speaker today is Caleb Logan, who's a lawyer with Elder Law Advocacy San Diego, and I'll introduce again in a moment. So today we have no financial disclosures, and our housekeeping today, we have 10 to 15 minutes at the end for Q&A. So we're going to get through the content, but throughout, please, and if you've attended other webinars, you'll notice that you can put your questions into the Q&A function or the chat function, although we prefer the Q&A. I will be monitoring that throughout as Mr. Logan is speaking so that I can answer some questions in the moment. And then at the end, I'll really be kind of putting them together so we can have a robust conversation at the end. We have continuing education credits, and that information will be presented at the end as well. You got to get through the whole webinar to get through to get the credits, but then we also email out that information too if you'd miss it or have to leave a little bit early. We also always put the recording of the webinar up within 48 hours. That's also on our YouTube channel, as are all the other webinars. So really look forward to having you watch it again if there's more useful information. And we usually are able to include the slides as well as a reference. So hope you can take notes and pay attention, but also just enjoy the presentation as it is, because we'll give you that information later. As a reminder, Dementia Care Aware has lots of program offerings, and just want to emphasize that for those who are just getting to know the program, you can find everything at our website, dementiacareaware.org. You can always reach out to us at our email, dca@ucsf.edu. Probably the core thing that people know us for is our trainings. We have live trainings and online trainings around dementia screening and issues that come up with dementia. But we also have access to practice support if you're doing dementia screening or other care in your primary care practice and want some support with that. We have access to many free and amazing coaching programs, especially ongoing through the Alzheimer's Association Health Systems Program. And then we have additional educational offerings like ECHOs through UCI and UCLA. And we have a warm line for direct sort of clinical consultation on dementia care if you need that, and email follow-up and things like that through that program. So great. Many of you know that the core of our program, and I'm going to go over it as I always do at the beginning of all our webinars, is how we train people to screen and detect dementia, called the cognitive health assessment. It's really an approach to screening for dementia. And as you get to learn and be more familiar with our core assessment, you'll understand why things like the medical legal needs of older adults are so core to our program, even if we're talking about a really early moment in dementia detection, because the social and surrogate or advocates support of our person living with dementia is a key component of our assessment from very, very early on. Our core training online and offered live is how you learn about how to do a cognitive health assessment. Many of you have seen this before, the cognitive health assessment. It's meant to be this screening approach for adults 65 and older, and trains you how to take a brief history for people's symptoms of any cognitive change from baseline, use a validated tool to do a screen for cognition and function, which is part 2. And then part 3 is documenting care partner information. And again, this is where the legal needs really start to bubble up. We want to make sure you make use of our live training opportunities. On average, people really prefer the live training to the online training. It's a 1-hour training offered multiple times a week and it's free, and also has continuing education credits and goes over that cognitive health assessment and how to do it. So please go to our website to find opportunities to sign up for a live training. They're usually offered at the same time as this webinar, 12 to 1 during a weekday. Okay, so now we've gone over the program, and I appreciate you all spending a moment to learn more about it and connecting with us if we can be helpful. But today we're going to get into the meat of our topic. So our learning objectives today are to describe the components of capacity from a legal perspective. List 1 or 2 roles a primary care clinician can have in assessing legal capacity. Identify 2 factors that can affect an assessment of capacity in an older person with dementia. Understand the importance of comprehensive advanced care planning for all patients. And again, I didn't introduce myself yet, but I'm Anna Chodos. I'm just going to moderate and make sure we have a good, robust discussion at the end as well. And I'm the executive director. I'm a geriatrician at UCSF and the executive director of Dementia Care Aware. And then Caleb Logan, who I really had the pleasure to watch him speak on this topic just a couple of weeks ago at an in-person workshop we did in Imperial County. So grateful to him. He's so knowledgeable. As a staff attorney at an elder law and advocacy organization in San Diego. And I know we're all going to really learn a lot. So really appreciate you coming, Mr. Logan, and I will turn it over to you. I did want to, I forced him to let me insert this one slide, which is the reason we're going over this topic. And I hope it'll give you guys and sort of implant some food for thought as we're going through this topic, because this is what really interests me about this topic. Personally, as a general clinician and as a geriatrician for older adults, which is how often is this an issue and how should we be thinking about this in people living with dementia? So that's the population we're constantly talking about here at Dementia Care Aware. And we know when it's relevant, can often be a really sort of critical issue or a meaty issue, I would say, something that we're really spending a lot of time dealing with. But is this something that's affecting all of our patients with dementia? Should we be trying to assess it in all of them? And if so, how should we be thinking about it for our general person that we're caring for that has dementia? Is it a relevant question? So now I really need to pass it over to our expert. So thank you for indulging me, Mr. Logan, and I will pass it to you.
I do, before I get started, just want to give a quick shout out to all of our partners in this DCA statewide medical legal partnership. These are a lot of great organizations here, both in the healthcare services area and on the legal services side of things. Again, also thank you to Anna and everyone at UCSF for bringing us here today. So, with that, I, as Anna mentioned, am an attorney at Elder Law and Advocacy. I've been with Elder Law for about 3 years. Before that, I also worked at the Legal Aid Society down in San Diego. Elder Law is focused on San Diego and Imperial counties, and we primarily give free legal advice to adults who are 60 and up. Even though we may not be in your area, there are several analogs throughout the state, especially with our health insurance counseling and advocacy program called HICAP, which gives advice about Medicare options. That's a very robust statewide program that you are able to look up online and find one in your area. And then on the legal side of things, we do also have other organizations, for example, in the Bay Area with Legal Assistance for Seniors, Open Door Legal, and other legal aid type organizations that can give similar services to elder law. I specifically am doing work with this medical legal partnership project, and then I also handle elder abuse, particularly financial abuse litigation and nursing home rights, neglect, and abuse cases. All right. So, getting started, and Anna briefly introduced our learning objectives for today. What we really want to do today is to introduce the principles of legal capacity, and we'll do that through the lens of a couple of cases. So first with an attorney and a client, and then also one with a doctor and a patient. After that, we'll work on applying the principles of capacity to situations involving medical providers just to more fully illustrate how it would look in practice. And I want to briefly bring up estate planning, or as many people refer to it, end of life planning. I don't really like calling it end of life planning because even though a lot of these issues come up at the end of someone's life, really it's always important to do, no matter what stage of life you're in. So that's why I have the end of portion of that in parentheses, emphasizing that this is really life planning, planning for your life. So with this area, we often have wills and trusts, and there are whole different types of trusts, so you don't need to remember all of those. We also have advanced healthcare directives. In some states, those are called healthcare powers of attorney. And then we also have financial powers of attorney. Often you'll hear that referred to as a durable power of attorney, which I tend to avoid calling these just because durable is actually a legal term saying that the document will be in effect both before and after someone loses their decision-making abilities. That's why I just like to reference the financial side of things because that's what these documents cover. And then we have all of the accounts that go into specifying a beneficiary. With bank accounts, that could be a payable on death account. We also have retirement accounts with beneficiaries on it. And at the end of the day, all of these different documents and accounts need capacity to actually make a change or put it in place in the first instance. But what actually are the capacity principles in terms of what the law covers? Generally, you can think of capacity as just the ability to make a legally binding decision. So without capacity, sure, you can make a decision, it just won't be legally binding. And historically, people were referring to this concept as competency, but they used it as more of an all or nothing term, which meant that too many rights were being taken away from people. That led to some reform over time, and now there's less of a mention of competency so that we can instead focus on a situation-specific term, which we are calling capacity. And with capacity, it's really, again, not like competency with all or nothing being the focus. With capacity, we're asking whether someone has capacity to do something, not whether they actually have capacity, end of story. So this means that someone could have capacity to do one thing, but maybe not another. And the laws in California that have clarified this term also define capacity in a way that protects people's decision-making power much more than competency did. So I mentioned that different standards might apply. Someone might have capacity to do one thing or another. For example, maybe they can make a will, but not a contract. In any case, when we're approaching evaluating someone's capacity, we're instructed by the law that capacity is presumed. I think of a better word for presumed being assumed. So presumed is actually just a legal term, and I want to avoid legal jargon as much as I can, just because I understand that's pretty inaccessible for people who aren't dealing with these words every day. A legal presumption, if you think of it, just shifts the burden of proof. The most common burden of proof people are familiar with is the criminal law version of beyond a reasonable doubt. With civil cases, so non-criminal cases, we are generally trying to prove things to show that something is more likely than not. Much lower standard than beyond a reasonable doubt, of course. And so with presuming capacity, that means that someone doesn't have to prove that they have capacity. It's actually on the other side to prove that they don't. Now, in terms of the medical framework, with medical decision-making capacity, you can see, again, this is a specific standard to the situation. So this means that with medical decision making, we're looking at does the patient actually understand their medical condition? They don't need to be experts in it like you all are, but as long as they understand the basics of what's going on, and are they able to communicate their choice, that could even be in a nonverbal manner, perhaps. Can the patient describe the implications of their decision? And that means whether they're able to evaluate the risks, the benefits, whether there are any alternatives that they could be considering as well. And then you want to be sure that they can actually explain their decision rationally so that they aren't just making it as an off-the-cuff decision or just making a decision to be done with that decision-making process. Now, since this is a framework for specific medical decisions, that doesn't mean that it's appropriate for understanding someone's capacity to do non-medical things. That could include financial matters with the power of attorney, for example, or just even the ability to live at their own home. The assessment at every stage of the process needs to fit the type of capacity that is being assessed. And with that, we'll move into a case example with Maribel. She's an 80-year-old woman who's meeting an attorney to discuss advanced planning documents. She's widowed and has 3 adult children, and she lives with her daughter Maria, who is her primary caregiver. Maribel uses a walker and has a diagnosis of dementia, and Maria made the appointment with Maribel, and Maria also provided most of the answers to the intake questions. She also brought Maribel to the appointment. The attorney asks Maria to step out and meets with Maribel alone. During the meeting, the attorney explained the advanced planning documents to Maribel, who listened and nodded yes. At times, she seemed distant during the meeting and may have even nodded off. When the attorney asked Maribel if she had any questions, Maribel said no. So, with this case example, what we need to figure out is whether Maribel has sufficient capacity to prepare these advanced planning documents. With this, we can revisit our understanding of legal capacity. Again, it's simply the ability to make a decision. We've moved away from the all or nothing idea of competency, meaning that the capacity standard is issue specific. With that standard, we're asking, does Maribel have the capacity to create an advanced healthcare directive? So it's a capacity to do something, not capacity, period. There is a presumption of capacity, as always. That will be our starting point. And legal capacity, since it is issue specific, situation dependent, that means that it is fluid. So someone might lack capacity on one day, but have it on the next. It can change depending on medication, how tired someone is. Uh, maybe they're going through a stressful situation in their life, and that's affecting their decision-making ability just for a short period of time. Whatever it may be, capacity will always be changing depending on the circumstances. And one thing to note is that capacity is not determined by a diagnosis of dementia. So even if someone has dementia, they might very well still be able to uh, make decisions just as normal, especially if you're working with them at a time that's better for them. For example, maybe the morning rather than afternoons. As for the formal legal structure around this, California organized laws passed by the legislature into codes, and I might mention statutes from time to time. Statute is just the word for a law that is passed by a legislature, as opposed to, for example, we have case law with the rules that courts make, and we have constitutional law with our constitutions. So California statutes are all arranged into these codes. We have, for example, the probate code. I work a lot in the welfare and institutions code because that's where we get our definitions for elder abuse. Family code, that is especially prevalent in domestic violence situations. So all of these codes are out there, but today we'll be primarily focusing on the probate code and specifically the Due Process and Competence Determinations Act. This is the law from which we get the rebuttable presumption of capacity. Again, going back to that legal word presumption, when a presumption is rebuttable, that just means that you are able to disprove a situation. So here, you are able to prove that someone doesn't have capacity. The law is not saying that people always have capacity. If it did that, it would be called a conclusive presumption. Um, this law, the Due Process and Competence Determinations Act, again, is where we get the law that a diagnosis of a mental or physical disorder, for example, dementia, does not equal incapacity. Instead, what it says is that there has to be evidence of deficits, and not only that, but those deficits have to significantly impair the person's understanding of a specific action or decision. So note here that there not only needs to be a deficit, and that deficit not only needs to be tied to an act or question, but it actually needs to significantly impair, not just impair to a minimal extent. And then, of course, the law defines capacity on a continuum. So a patient's presentation medical history will give evidence of whether they have capacity to do something, but it's not, again, conclusive in any way. So let's revisit Maribel. The attorney did not prepare the documents at the first meeting. Instead, the attorney met with Maribel a second time, this time in the morning rather than in the afternoon. Now, at this appointment, Maribel spoke clearly about her family and described that Maria was a huge help to her. The attorney explained the Advanced Healthcare Directive to her, and Maribel stated that she wanted to name her daughter as agent since she's my right hand. Maribel also says that Maria would know the healthcare preferences she would have, but also stated that organ donation would be okay. Maribel said, I don't need those body parts anymore after I die, so if they can do some good, I would like that. The attorney also asked about life support treatments. Maribel indicated she wanted no such treatments, simply saying, when it's your time, it's your time. Clearly, this meeting is going very differently than the first one did, and that just illustrates the incredible fluidity of capacity. But how do we actually decide whether she has capacity or not? There will be some variation on the meeting depending on the attorney or maybe other circumstances, but these guidelines generally do follow recommendations from the American Bar Association. So generally, the attorney will meet with the client alone. We want to make sure that there's no third party coercing the client or influencing them in some way. And also, we want to preserve the attorney-client relationship. So, in the law, we of course have the attorney-client privilege, which means that lawyers typically don't need to disclose information about their client. When there are third parties present, it can limit our ability to keep that information private. So, by meeting with the client alone, we're actually able to uh, preserve that privilege should the need ever come up to, uh, discuss it in court. Because the law has a presumption of capacity, that's what we'll always be assuming when we go to meet with a client. And then we'll have to determine what level of capacity applies to the given situation. So, for example, we have our decision-making capacity from the probate code, and that little squiggly symbol is just a section symbol, also called a silk row, and you can just read that as sections. So we have probate code sections 810 to 812 first off with that decision-making capacity. We also have a law that applies to contractual capacity, and this governs powers of attorney. It also applies to more complicated trusts. The simpler trusts and also wills have the testamentary capacity standard. You can remember that word by thinking that wills are sometimes called a last will and testament. Then we have advanced healthcare directives and a standard that you're likely more familiar with, informed consent. So then after we identify that standard that applies, we're going to look at any deficits that appear and figure out whether there's any correlation with a deficit and the person's ability to appreciate the decision that they're making. And again, it can't just impair that decision, it has to significantly do so. So using these standards is something you're likely familiar with. You do it with informed consent all the time, and you simply use that standard, identify if there might be any deficits, and then determine if it's significant. The lawyer is doing the same thing, just applying slightly different standards. These all spelled out in the law. at the specific appointment. So I'll move through this very quickly. I don't expect you to know these laws or have experience applying them. It's just to give a full picture of what we're doing. Again, you're trying to figure out if deficits significantly impair Maribel here, her understanding of the nature and consequences of her decision and whether she can communicate it. So this one, since it's for advanced healthcare directives, of course, includes thinking about proposed healthcare. And really goes back to the earlier slide on communicating that decision, understanding what's wrong, and understanding the benefits and alternatives and any risks involved. And I do just want to bring it up that even though the law already has that presumption of capacity, here it gives another reminder just to make it ever more clear that patients are presumed to have capacity to make healthcare decisions. Again, capacity is designed to reinforce people's rights and not take it away with the competency standard that we had. The capacity to contract, again, you can focus on that need for communication, verbally or by any means, and they also need to understand and appreciate, to the extent relevant, all of those uh, issues involved in the decision. So any rights that are involved, the consequences that might come from it, if there are any alternatives that could be better. And again, this standard does apply to financial powers of attorney. The thing to remember here is that this is a pretty high standard. It's actually the highest standard that the law gives for capacity to do something. So it is harder, but really, as with all of these laws, is tailored to the specific circumstances. You'll notice how I said earlier that it's um, considering these different subsections here to the extent relevant. Capacity is issue specific, situation dependent. Therefore, we're only considering what actually applies in a given situation. Now, there's also the capacity to make a will. That's what I called testamentary capacity earlier. And this is actually defined a little bit differently. It does use that old competent word. And it says that someone is actually not mentally competent to make a will if they have certain issues. And really, this all just comes down to knowing what property you're able to give away, knowing that you can use a will to do that, and knowing your family. All right, I also do want to quickly discuss supported decision-making agreements. These are agreements between an older adult with a disability and someone the law calls a supporter. There can be multiple supporters, and their role is simply to help the adult understand information and communicate decisions. That covers a pretty broad spectrum of possibilities. So it could be the healthcare setting, maybe the supporter is participating in care planning, or it could be the financial setting with communicating with financial institutions and planners, whatever situation arises, really. These agreements, importantly, don't stop the adult from acting independently and can't be used as evidence of incapacity. They're just there to help someone with a disability manage their own affairs and make decisions. So, in other words, it boosts their capacity, if anything. The law allowing these agreements just took effect in 2023. It's really just a response to wanting to minimize conservatorships, especially after the controversy, excuse me, that arose with Britney Spears's conservatorship. And since it's a new area, I can't say definitively how it will impact capacity decisions moving forward. I just wanted to raise it so that you're aware that there are tools in the law for helping people control their life, even as their capacity to manage day-to-day tasks might be limited, or grow limited over time. Also, whenever we talk about capacity, we always need to think about undue influence. So when people's capacity starts to decline, they can become more vulnerable. to undue influence, and I'll take a quick look at that law later on the next slide. We also want to make sure that there aren't any signs of fraud. And finally, the last step, we have to decide what our actions are going to be. So, do we need to meet with this person on another time because we think they may have capacity in the morning, like we did with Maribel? Do we need to look at some expert opinions from medical experts because we're just not sure and we want more evidence? Or do we decide that there is capacity and we're going to go ahead and move forward with making the documents in question? So in terms of undue influence, again, no need to remember this, memorize it, anything like that. Just to give you an idea of what the law says. Undue influence is often thrown around a lot, I think, kind of more in a colloquial term. But the focus that you want to think of with this is that someone is so persuasive, excessively persuasive, as the law says, that they actually override someone's free will. Basically, they're saying, this is my way, and making that person think that it's the only way. There are a bunch of different factors here, like the victim's vulnerability. Maybe they're dependent on the influencer for care. The influencer can also exploit apparent authority. For example, when we're doing financial planning, our financial planner could exploit their authority that they have. There are also actions and tactics that might be considered. So whether the influencer isolated someone, for example. The result with undue influence always needs to be unfair, but being unfair alone is not enough to show it. But let's look at our takeaways from Maribel, just to reiterate these basic principles that really I want you to take away today. We know that capacity is fluid. The attorney met with Maribel a couple times, actually, different days and different times of the day. Capacity is not dependent on a diagnosis, even if someone has dementia. Legal standards do provide guidance, but at the end of the day, the ultimate decision is a judgment call based on whatever evidence is in front of us. We have to look at if there's a correlation with the act and whether a deficit significantly impairs that act or decision. Now, getting to how medical providers can actually help. Well, I mentioned evidence just a few seconds ago. So, what is that evidence? That could be everything that is in someone's healthcare records, maybe how others see them interacting on a day-to-day basis, with or without the diagnosis. Documentation is key because it gives us pieces of the puzzle when we're looking at people's decision-making capacity. And if a situation does end up in court, the judge needs to know what impairments specifically apply. Are they there now? Were they there when the disputed transaction happened? All of those issues are important for the court. And again, these are just a piece of the puzzle, but the law does focus especially on deficits that are in areas I understand are in your assessments. These just basically include alertness and attention, information processing, thought processes, and also someone's ability to modulate the mood and affect. So, how can a medical provider help given this document issue? Well, for one thing, you can document over time. I mentioned previously that knowing that capacity is fluid can help guide the patient to a referral, but really you can use it to guide your appointments. So that could be making multiple visits with a patient. Maybe you encourage them to make an appointment at a different time of day, a different location, if that's possible. That can all provide a more complete picture of someone's capacity because the more evidence that someone has, the better. And you can also use the cognitive health assessment that Anna mentioned at the beginning to assess someone's uh, capacity and make further assessments. But I'd like to go through another example now. This is Theo. So Theo is 76 years old and is at his doctor's appointment. He seems not to remember what you spoke about at a previous appointment and is not taking his medications. Theo just had a cognitive health assessment and is showing significant cognitive impairment, specifically with his memory. Looking at his record, you notice that he doesn't have a power of attorney. So what we're looking at here is whether it's too late for him to do advanced planning given his diagnosis and that significant cognitive impairment. The probate code again will give us guidance. We know that presumption of capacity applies to everyone, and so that applies to people with a diagnosis of whatever it may be. The law specifically says that someone who has a disorder of any type may still be capable of contracting, and any loss of capacity should be based on evidence of a specific deficit, not a diagnosis. So at the end of the day, whether it's too late or not isn't a question I can fully answer for you. Really, it's something that you'll likely have some institutional policies about, but I can give some context to how it plays out in the law. This is a huge amount of information. Again, I don't expect you to memorize this or recall it quickly or even at all, but this is what the law does provide. Again, it has those four categories that I highlighted earlier. And with your medical opinions, you can give evidence of these different categories. And also, maybe if it correlates between a certain action that is uh, at hand. The law, of course, does go into much more detail than just giving those four categories, end of story. And the capacity declaration for conservatorship application actually is a pretty good cheat sheet of this language. But even though that may be the case, I want to emphasize that I'm not mentioning that declaration to say that everyone needs that form. I just want to show here that it is these functions and their deficits that the law makes a big deal out of and what will be evidence moving forwards if it ever got to a court case. This slide is really just a summary of the law. So we know that we have our presumption of capacity. We know that it's fluid. It doesn't depend on a diagnosis. Legal standards like these ones here give us guidance, but the ultimate decision will be based on the evidence in front of us, just making a judgment call. Contractual capacity I mentioned earlier is the highest standard, and that does apply to financial powers of attorney. But the lowest standard, on the other hand, which I don't believe I said earlier, is testamentary capacity. That's making a will or a simple trust, just basically understanding what is going on and who is around you. You'll notice with all of these that they are issue specific, so it's making sure that people understand a decision in the context that they're making it in. And at the end, you'll notice that I throw up probate conservatorships. Um, that always needs to be the least restrictive alternative to protect the person. You can recall supported decision-making agreements, and I mentioned the controversy around Britney Spears. Again, that led to reform in the law recently that really emphasized we do not want to place people under a conservatorship unless they truly need it. And with that, I would like to just briefly revisit life planning, as I called it, because we get a lot of people who ask, how can I get a power of attorney over my parent, spouse, sibling, whoever it may be, who has dementia and can't make their own decisions? So one thing you can say, well, we know a diagnosis does not determine capacity. So really, it doesn't matter. But if they truly can't make their own decisions, their dementia or whatever condition is so extreme, you cannot get a power of attorney over them. And that is where conservatorships really enter the picture. So you can request a DCA training on this if you have any questions. Um, with probate conservatorships, you can kind of think of it like the documents that I was talking about earlier. We have advanced healthcare directives on the one side for medical decisions, and then we have financial powers of attorney on the other for financial decisions. And the law splits this up with conservatorships into a conservatorship of the person and a conservatorship of the estate. Now, one person, when they are conserved, might have one or both of these apply. So just because someone can't make medical decisions, for example, doesn't mean necessarily that they can't make financial decisions. It just depends on the situation. The important thing to note is that even though we have these medical and financial controls, someone, no conservator, that's the person who is in control of the person under conservatorship, can control who calls or visits the conservatee. They are able to request a restraining order on their behalf, for example, an elder abuse restraining order, in my context at least. They're also, um, they aren't able to create a will or direct the distribution of the conservatee's estate after death on the financial side. And actually, the law does say that people who are under conservatorship are able to make a will. There actually has to be a judicial decision saying otherwise for them to be unable to do so, reminding yourself again that the testamentary capacity is the lowest standard, and the law is designed to be the least restrictive possible. But knowing that capacity is so fluid and not everyone does need to be conserved, thankfully, how can you specifically document a meeting with a patient so as to give the best evidence? For one thing, since it is fluid, always state the date and time of your assessment, state whether the capacity to do something should be reassessed within a specific period of time. Maybe, for example, 2 weeks if they're going through a stressful situation that might disappear in that time. And always encourage the patient to participate in a reevaluation if you have specific concerns. You also want to rely on standardized tools just to streamline it for you. So again, there's that DCA cognitive health assessment training on how to conduct screening and follow-on diagnosis, including self-reporting versus caregiver reporting. Always keep notes on, for example, what tool you're using, whether you want or did additional assessments to reach a specific diagnosis. And you can even try and note some of the exact responses that the patient is providing. At the end of the day, just remember that positive cognitive screen does not automatically mean that a patient lacks capacity for all decisions. You also want to rely on your institutions. So this could be um, from your risk management office, maybe. Don't rely on this program for legal advice about a specific situation. You're always in charge of your own medical judgment and in charge of following the advice of your ethics committees and any legal counsel involved with your institution. Always be aware of any applicable local standards or policies for assessments. So, for example, the scope of practice, privacy, elder abuse reporting, and all of that. Fun stuff, I know. A few pitfalls to avoid. These are really just corollaries to the standards that I mentioned earlier. You always want patient consent before providing a letter about capacity. Focus on a specific deficit for an act in question. You don't need to recite patient history that's totally unrelated. And in fact, you want to avoid writing general sweeping statements instead of specific function-specific analysis. It's not your job to make a legal conclusion or do any legal analysis. That's ultimately for a judge to decide if that applies to a certain situation. So don't put that pressure on yourself. It's not your role. And again, with capacity being fluid, don't assume that it's constant. And since it doesn't depend on a diagnosis, do not assume that a dementia diagnosis will determine someone's legal capacity. So again, I mentioned those are kind of corollaries to the takeaways from this presentation. capacity is issue specific. It's not patient specific. It will be a continuum and it can come and go. Nothing determines capacity definitively, whether a medical diagnosis or otherwise. And the most important thing you can do as a medical provider is document specific deficits. And with that, I believe I'm going to hand it back to Anna.
Thank you. Yes. I just wanted us to think again about that, the food for thought question, which is when I'm working with my patients who either we're detecting something because we've done a cognitive health assessment, or they now have a diagnosis of dementia, or in the middle, you know, does that mean they don't have capacity? And I think the big take home for me, or the way I tend to think about it, is it's certainly more likely that they may have difficulty with some decisions or processing some information. That's kind of part and parcel of the disease process or the syndrome, but it doesn't mean we still have to determine it in that specific moment for that specific decision. And what Mr. Logan was going over so carefully is just all these different kinds of capacity that we really need to rely on our legal colleagues to help us in other scenarios. But for medical decision making, that and general assessment, we need to be documenting how they're processing information, if we feel they have capacity for a certain decision in a certain moment, and why. And then other things we might notice, like their ability to pay attention or their ability to express themselves and use the language, and reasons that capacity may be diminished or harder to assess. And then just the humility that we really may need to keep assessing and relying on experts and legal experts, and kind of working as a team. And so I hope that this particular webinar shows like what a team sport these issues are, and how in medicine and in primary care we have this incredible privilege of really knowing our patients well, but then on the other hand, we're really more limited in knowing all these ins and outs of the legal details. And so we have our role, but that if we're really going to work with a patient towards the end of a like a conservatorship or something like that, that is such a serious thing that we're sort of only part of the puzzle that really ends up being a legal determination. So actually a couple of them are in the category of when can we use a power of attorney, and legally. So one was, if the person can't make decisions and hasn't designated anyone, can someone else, like a oldest child or legal spouse, answer on behalf of the patient? And then it's very related, so I'm just going to lump it together. When they've designated somebody, but that person themselves loses capacity or is incapacitated or has died, what do we do about that? So that's a scenario where we have somebody who really may not have either a legally appointed or an adequate advocate. What would you recommend, or like where is that person legally?
Right. They are actually kind of in the same situation with both. So with the second example, since the person who has that power to make healthcare decisions for the patient loses capacity to do so, then that kind of negates the authority that the law otherwise gives them. And with that, it's assessing the situation as though the patient didn't actually ever name someone in the first place. So they're both in similar situations, and the law does generally say to it. I can't give an exact definition of the law, but it's essentially referring you to uh, the most relevant person. So if they have a spouse or partner, it would be, well, I shouldn't say partner, just because the law is very specific. If it is a spouse, then they would generally be the first option. Otherwise, it's closest family members. And your institution might also have some policies on that point. What I would also want to mention is that if the person who's named in an advanced healthcare directive doesn't have capacity to make a healthcare decision for the person, there might be a second person nominated to have that authority. So make sure that you're reading through the Advanced Healthcare Directive fully just to see if there is actually someone else that you can be reaching out to there.
Okay, stop the presses. So I've definitely heard that in California, we're not allowed to just go to the next person. But in practice, like certainly in a family meeting, we're sometimes nobody even really checks if the person has healthcare. I'm not talking about myself necessarily, but we're just trying to be practical, and we're making, I think,
Mhm.
pretty good decisions around who probably knows this person and who has their best interests in mind and all of that. Um, but it sounds like it is okay to go to sort of a next of kin situation, but maybe it's not like fully legally fleshed out or something like that. Can you say a little bit more?
Yes, so I haven't heard that you cannot do that actually. And I can't say I have the law memorized, but that is very interesting. So, because I'm a little bit more familiar with the financial powers of attorney, where it's very common to actually name different people that who will take charge in the situation where someone isn't able to do so. Um,
Okay, so
so as
not
far
designated, but the person's unable, and we could legally, like, it's not inappropriate to turn to a spouse.
Mhm. Yes.
Okay. Because certainly practically that happens all the time. And I think, again, I just, in deference and out of respect to all my colleagues, I think everybody's trying to do the best they can for the patient. And, often it's just a tricky situation and these things aren't done ahead of time. But I guess what I'll say is, and the point I really took from your talk, and I really, really want to emphasize, is just how important, if ever at all possible, and it should be more possible, to just do this way up front. And I loved your framing as life planning, because definitely, it's like all the other bureaucracy and paperwork we have to do. The more we can normalize, we just have to get this done. It protects you, it protects everybody. It helps people in your life know that this might come up, and none of us know the future. It doesn't mean I think you're particularly ill or that something's going to happen tomorrow. It's just, we have to get this done. It's just part of life. And it's so I always present it in sort of that
Mhm.
normal and boring kind of ways, so that it just takes the valence off of like this is about the end of your life or something like that. But I do try to get it done as soon as possible, and I think you really emphasize that um, we need to, it. Hopefully, people do it when their mind is as sound as it can be, and is capable of processing all the information, because it's potentially harder later on.
Right, and the making these documents, whether it's I mean, advanced healthcare directives are a great example just because people can have very nuanced decisions about what they want to be made or what decisions they want to be made at the end of their life. And it can even, you are able to make it lighthearted. So, my parents both went to USC for college, which means that UCLA is horrible. Um, so my dad said that his body could go to a institution for research purposes as long as it's not UCLA. So you can just do funny things like that. The law lets you have fun with it, but at the end of the day, it's really important just that these conversations are actually being had so that everyone around you knows what your choices are, even if they may be neurotic, erratic, whatever you want to call it.
Idiosyncratic, yes, that's
Yeah.
a very funny one. That's a good example. Um, the next question I think ties into what you brought up around knowing your institution's policies. So someone pointed out, and I thought this was a really good question. When you ask a patient, is it okay to talk to your sister or your son who lives with you about how you're doing? Um, is it okay just to document that in the chart and then sort of proceed, as opposed to having another legal document established? And in this case, the thing that came to mind was release of information. I know in some settings, like a mental health setting, there's specific, often policies, if not laws, governing that. So you'd want to be more careful. But if it's around a health condition like dementia, um, and I'll emphasize to the audience, like dementia, it's part of the clinical workup to talk to an informant. It's an actual part of the workup. Like we can't really get the full answer or the full diagnosis if we haven't done that. So in my mind, it's even more reason why it's very justified. But do you have anything to add about sort of the legal context of talking to people about the patient and being sure to document it properly and being, as respectful and safe for the patient and for our institution and our careers, I guess?
Right, definitely documenting it would be a good idea. Like I said, the more evidence, the better. And so even for that applies to every situation, just for example, documenting that someone has allowed you to speak to someone. And that's something that I always do when I'm talking to a third party about something that a client is dealing with. I make sure that I note that the client actually gave authorization to speak with them. That's for client confidentiality purposes on my end. But for you, it would be for HIPAA purposes, making sure that you're not disclosing healthcare information about a patient without their consent. So very, very similar situation, but similar context that would be informing that.
Do you have any advice about like if it's okay to write like gave verbal consent versus if we should have a signed form from the patient? Sorry, I don't know if I missed that. I was reading one of the questions and it came up.
Right. Well, in the law, evidence is only as good as the form it's presented in. So if you have reason to think that someone might challenge a verbal authorization, then you can always request a written authorization and just scan that into the file. That way, a written request is or authorization is much harder to disprove than saying that it was verbally made.
Mhm.
So I would say probably not necessary, but if you are in doubt, that would be the safest route to get it in writing.
And I would say it's okay and probably preferable to ask your like clinic director or whatever if you have a work somewhere that has a policy and make sure everybody's like doing the same thing or at least aware of how you're practicing. And then I would also say, I usually when I call, I say, hey, I had an appointment with your mom, and she said it was okay to call you just to see if there was anything you wanted to add about how she's doing. And I don't actively disclose information other than she had an appointment with me about what we're working on or any health conditions. I don't just start listing like what the person's visit was about necessarily. Yeah, that's another tip to maybe keep like the information flow coming to you as opposed to like violating HIPAA, even though it's already sort of dicey if you're just saying you had an appointment. Um, we are basically at time. I want to acknowledge there was a couple more questions about who can make decisions for the person if they can't and there's nobody designated. And again, I think the things to look at that you mentioned are, again, double checking that there isn't any documented person or any like registered advance directed with the state. There's usually not. Um, if you have a particular healthcare policy, and I believe the laws might be different between like if you're practicing in a SNF, a hospital, or a clinic, because there's different resources. So local policy, and then what practice environment you're in. And then we'll send up as a follow-up with a slide with these with this presentation when we post it, just like a summary of resources for that, because I have heard different things that sometimes places, won't allow a next of kin to just jump in. And, but acknowledging that that's often a very well-meaning and established practice in most places that like a child or a spouse will sign, for a procedure or something like that, even if the full DPOA is not completed. Um, but that conservatorship often gets involved when nobody who's really established is available, or it's like the person's looking for broader powers of estate or, full decision making of the person. That's when they might go to have to go through a legal process to get those powers, as opposed to just consenting to like a knee injection in clinic or something that's like relatively small. So to those who ask more and more questions about that, we'll provide some follow-up information in the slides, and really, really appreciate all the incredible resources you gave us today, Mr. Logan. And so appreciate your time and the way you constantly make an effort to explain to us in more lay terms some of these legal terms and the way it's thought about. So thank you so much.
My email will be in the slides that are sent out as well, so feel free to reach out if you have additional questions or just have any question really. Like I said at the Imperial event where I met Anna, I like just talking about the law, so if you want to contact me with anything, feel free.
Thank you so much. And everybody, we have a whole medical legal network page on dementiacareaware.org. And you can look through the resources as trainings on all this stuff and additional handouts for all the medical legal topics, especially those having to do with dementia. So please explore there because I saw some extra questions. Again, thank you, everybody. Have a wonderful afternoon. And thank you, Caleb.